So good morning, everyone. We're really excited to have you here. I'm Tony Ann Nunez, and I am the Director of Pro Bono Programming at the Colorado and Denver Bar Associations. And in that role, I'm really excited to work with the cannabis law section with respect to everything that we're going to be doing in the pro bono arena. So part of this is to educate you and let you know a little bit about the cannabis law section. And part of this is to really encourage you to join our pro bono efforts and sign up to help. And Rachel's going to talk a little bit more about what that specifically means and how it's going to help and how we plan to have the pro bono cannabis section help people in our community as well. So welcome, everyone. I wanted to do a quick thank you to our speakers, James Wilder, and of course, Rachel Ardanuy. April McMurray is also here from Attorney Reg, and she's going to do the beautiful thing for us as far as responding to things in the chat. So because we have a full schedule today, we are not going to actually stop for questions and answers. Hopefully we'll have a little bit of time at the end, but Rachel and James and April and I will all be watching and monitoring the chat and trying to figure out how we can help your questions as we go. So again, thank you for being here, and it's exciting to have you all on board. I'm going to start by introducing James. James Wilder is an Assistant Regulation Counsel for the Colorado Supreme Court Office of Attorney Regulation. He graduated from the University of Denver in 1997 and will complete an LLM in Germany in 2021. I guess you must have done that, seeing that we're past that, James.
Yeah, that's actually a typo. It's 2022. It's this year. So
okay, thank you. He clerked for the Honorable Edward Simons of the Denver District Court, and he was an associate at two medium-sized law firms before opening his own practice in 2005, and where he worked until he joined the OARC group. So thank you, James, for being here. We also, of course, have our speaker, Rachel Ardanuy. She is a cannabis business attorney licensed in Colorado, Florida, and New Jersey, and the founder of cannabis business law firm RZA Legal. She has dedicated her career to advising and educating on any issues related to the cannabis industry. She is the immediate past chair of the Colorado Bar Association's Cannabis Law Section and serves on the advisory board to the Colorado Marijuana Enforcement Division's Social Equity Program. We'll hear more about that today, and frequently presents on different areas of law. So again, thank you all for being here. We are recording this and we'll put it up on the website. All the materials will be shared with you after the presentation. So thanks, and I'll hand it over now to James.
I thought Rachel was going to say something quickly before I got.
You can do a little intro.
Yeah, so one of the main reasons we scheduled this CLE now is because over the summer, we were approved through the Colorado Bar Association's Executive Council to establish a pro bono referral service for social equity applicants in the cannabis industry. And while you may not understand what any of that means right now, by the end of this CLE, you will. James is going to talk today about the ethics of providing pro bono services generally. And so that way, all of you future volunteer attorneys will have a clear idea of what the ethics are of providing pro bono services through a pro bono service program that the bar puts on. Tony Ann is an amazing resource as well. She is the pro bono guru here. And so any questions that you may, follow-up questions on that you may have, she is an amazing resource. And then I'll pick up once James is finished talking about pro bono ethics. I'll talk very briefly about ethics, ethical issues that we run into when guiding cannabis clients, and then generally, what the program is, what the social equity program is in cannabis, why we need volunteer attorneys for this, and some additional resources to get you updated on what the issues you will see as a volunteer attorney working with social equity applicants in cannabis, what the ask is for the pro bono program, and then further resources if you'd like to delve sort of further into the substantive areas of cannabis law. So again, thank you so much for attending today, because we are planning on rolling out this program pretty soon. So I'll hand it over to James now. Thanks.
All right. Thanks, Rachel. And just while I'm getting my screen share up so I can share that, I'm going to start with, I guess, some of the big questions, including the ethical question: pursuant to the rules of professional conduct, can you advise clients about buying or selling cannabis. And as we mentioned, we are going to use the chat. So feel free to start mentioning what you think the answer to that question is, and what rule of professional conduct we might be talking about that gets implicated. And just give me 1 second here while I can't talk and click buttons at the same time. So here we go. All right, everyone see that? So, and then we'll get into some of those specifics. But Rachel, as Rachel said, we're going to start using this in the chat as well. So April's going to do that. I'm going to try not to interrupt and try and get through all of this with time by not stopping for questions. But April McMurray from our office is happy to do that. So, well, so the rule of professional conduct that I'm referring to is Rule 1.2D. Which you can see, of course, says a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal. I guess I'm also going to ask, why would that be important when we're talking about cannabis? Is there a difference? I've heard something out there about there being a difference between state and federal law on that. Now, while you're mulling that over and thinking those implications, of course, let's look at what did the Colorado Supreme Court do about this conflict between wanting lawyers to be able to advise clients about the law in Colorado and Rule 1.2D. And of course, here's the answer. We have a comment 14, and then I'm just going to talk about this briefly and we can get on to pro bono ethics generally, but I wanted to get through this so we'll make sure we're clear on why we're talking about some of this. But the comment makes it clear that a lawyer can counsel a client regarding, you can see validity, scope, meaning these Colorado Constitution articles with regard to what was passed essentially back in 2012, I'm sorry. Et cetera. So that, but you need to be aware of that and also advise about the client regarding related federal law and policy. So that's just to get through that. I don't know if it's the question in there, one that's a little bit more applicable, but I wanted to make sure we addressed that right at the top and got through why we're talking about this. Why can we provide this advice generally? So every lawyer has a professional responsibility to provide services to those unable to afford them. I also want to start off with reminding everyone the importance that the Colorado Supreme Court places on pro bono service, because that's also something we're looking at. I'm also going to say at the top, I'm going to talk about some issues. We're going to go through some things that come up, how those rules of professional conduct are applicable when you're engaged in pro bono service. But I do want to say, we don't get at the Office of Attorney Regulation a whole lot of complaints that rise out of the pro bono practice. So I do want to be clear about that at the front. This is certainly not to scare you about the dangers of engaging in pro bono. It's more to encourage you and give you those tools you might need or think of, okay, now that you know that's what it is, hopefully you're more prepared to be able to go out and do that, including access to justice. I won't read through all of that, but the Supreme Court really has emphasized that. Just back, within the last decade, they enacted the preamble and being mindful of these issues where people do not have those resources to get access to the legal services. And it's just so crucial to the rule of law, the system of justice that we have, that individuals have the ability to get good legal advice. And so the more we can promote that, the Supreme Court has even made a few things easier for engaging in legal clinics. And we're going to talk about that in just a moment. But certainly it's something that we're also looking at. This is the framework when we're talking about pro bono work. And even when they come in, access to justice is an important part of that. So let's talk about, in particular, a legal night and some of these changes to the rules. I guess it changes. There's slight modifications that are supposed to make it a little bit easier. And we're going to talk to begin with about conflicts of interest, because there's a few modifications. When you're engaged in a legal night, you want to be aware, you want to make sure that you're, following the rules. So now here we are, you're at a legal night and you might worry, my firm or myself, I have a bunch of clients, what if I, unintentionally engage in a conflict of interest because I'm advising someone and I don't realize it? Well, don't worry. Rule 6.5 has it covered. So it's going to protect you a little bit. This is the way that rule plays out. If you know that the person sitting down in front of you, or this can also be, one of those call-in service or something else, but a limited legal representation. If you know that the person is a conflict for some reason, this is the opposing party, in litigations that's happened to call you or sit down in front of you at the legal night, well, you're going to need to say that and not provide the advice. However, if you don't know, as it does put it as a knowing a standard that of the conflict, then Rule 6.5 modifies the rules of conflicts of interest. That's Rule 1.7, which is the rule with regard to current clients. Rule 1.9 is the rule with regard to former clients, that only if you know. And Rule 1.10, which is the rule with regard to you have a conflict if someone else in your firm has a conflict, also is modified to this knowing standard. So you also can't do it if you know that, hey, I don't have a conflict, but I know my partner does in this case. But if you know that, then you're also going to have to pass on advising this particular legal night applicant. But if you don't know, then the rule is going to protect you that way. So that is a nice thing to, certainly encouraging that idea of go to legal nights. You don't have to bring your conflict checklist with you to be able to go and participate. But, you do have to be reasonable in that sense of, if you know that there's a conflict, you can't proceed. But that's that standard. Which also brings up a little bit this idea, and I want to talk about, representation of the client, because it can be limited, and we're going to talk about it. But when does that start? Because, and I'm going to try and do this without going down a long diatribe about the finalities of when we're engaged or not engaged in the practice of law, but we can talk about this a little bit. If you're providing, I'll oversimplify it a little bit and say, if you're providing legal information, you are, you're not engaged, generally speaking, in the practice of law. If you're just saying, the law says this, there's that, these rules are saying that. And I like to use the example even of my presentation now. If I'm just giving information about what the rules are, well, I'm not engaged in the practice of law. I'm just explaining what the rules say. However, if I start saying, hey, but in your case, this is what it means for either your past actions or what you should do in the future and things like that, then I am engaged in the practice of law. And generally speaking, that has created an attorney-client relationship. It's also important to remember that this is a reasonable subjective belief. And without getting too long into that, if the client reasonably believes you're their lawyer, then essentially you're their lawyer. So that, and I say that just to say, be aware of what those rules are that get implicated and excuse me, and we're talking about, and why we're going to be talking about a number of those rules, even when we're talking about a legal clinic potentially, where you just might be talking for 30 minutes. I mean, you may be their lawyer for 30 minutes. And hopefully, the programs and everything else are pretty clear about that. But I just want to be clear, because it doesn't depend on whether or not a fee is paid. Being pro bono doesn't mean you're not their lawyer. That hopefully that's a reasonably obvious. But I will say that has come up more than once in investigations where someone said, I wasn't their lawyer, they never paid me. That's not the criteria. Nor is signing a fee agreement. So although you had a 30-minute representation, you never engaged in, signed a fee agreement during that time. That's not the determining factor. It may be a factor in determining whether it was reasonable or not under other circumstances, but it is not the determining factor. So, excuse me. What, and someone may have, I'm getting a lot of extra noise. Someone can go on mute. If everyone could put themselves on mute to make sure we can hear, I'd appreciate it. Because you can engage in these limited scope representations. And that's the thing I want to be very clear about. That can be, it has to be a reasonable limitation, but there also, a client has to give informed consent. As you can see, this is under Rule 1.2. That can take many different forms. That, we may be talking again at a legal clinic, and so it's a, time frame. It may be limited scope in the sense of you're not monitoring an appearance, but you're helping them, draft pleadings, et cetera, for some longer representation. It could be, limited to one hearing, et cetera. There can be different types of limitations. It does have to be reasonable, but the client does have to understand that's the limitation. I mean, that's what this informed consent we're referring to is. The client needs to understand, oh, you're my lawyer, but you're only my lawyer for 30 minutes, or you're only my lawyer to draft this pleading, or whatever the case may be. So keep that in mind that Rule 1.2 does implicate that. Just define it and allow it. I also want to talk briefly in particular about Rule 1.18 and remind you about that, because you can, even if you don't have an actual client that results from the consult, that you may have you will have some certain amount of duties, and including confidentiality, not to use or reveal information that was learned in that consultation. And there still may be a conflict that comes up. It is a different standard, however, in the fact that the information you received, if it's not significantly harmful in that consultation, that wouldn't result in a conflict. However, if you did receive, significantly harmful information to that client, so again, that's really going to be factually dependent, but so it's hard to define generally speaking, but just be aware that that's slightly different standard than a 1.7 or 1.9 would be otherwise with regard to a current client or a former client. That's going to be out there. But even then, that potential conflict can be waived through informed consent. So let's go back to that legal clinic and talk about some of the parameters. And Rachel's going to talk a lot more, or Tony Ann can talk a lot more about the specifics of the programs that we're talking about today, certainly much better than I can. But generally speaking, you want to know what are those circumstances of what you can and can't do. Be aware. Can you, take that if it is a legal clinic for 30 minutes? Can you, continue to represent them? Maybe they might, and certainly likely that they might need more representation after that. Can they hire you or your firm or whatnot? Can you provide other names, to other lawyers? What are the parameters of that program, and to make sure you're complying with that, because different programs have different rules with regard to that. And you want to make sure you're being careful about what that is with regard to that. Not every program is just a marketing opportunity, but there's others where you might be able to do some amount of additional work. So let's go through well, let me ask this way. Engaging in pro bono work, you can answer in the chat if you like. Which of the rules 1.1 through 9.0 of professional conduct apply when you're engaged in pro bono work, or more likely speaking, which ones don't apply? Do that. See if we get any responses. And well, the short answer, of course, is they all still apply. Other than what we just talked about a moment ago, which is why I talked about them first. with limitations in a legal clinic, we are talking about all the rules of professional conduct. There's no exception to say, well, you don't have to be diligent or competent if it's a pro bono case. All the same rules apply. But let's talk about what that means, because it can still mean something slightly different in a pro bono case. And that includes this rule of competence, which maybe is on a lot of people's mind, which is why you're here today, to learn a little bit more, because you have to provide competent representation. Well, what does that mean? Because competent representation takes a lot of different forms in different circumstances. It does not mean that the first time you represent a client, you must have already become an expert in the field and know everything about all the law in every way. But it does mean you have to be aware of the fact that you are not an expert in the field and you know everything about the law. There are a few questions that you might want to ask yourself as you're doing that, including, if I need assistance, mentoring, what are my resources? And a lot of these pro bono programs, I would say almost every one of them provides some amount of resources in this area. Someone else that maybe you can turn to ask some questions, or resources or materials. Again, if this isn't your field of practice, which I might assume a lot of those today are this is not their primary field of practice, but they're maybe looking at getting into it. Just be aware again that is a limitation. So you're going to have to look at that and be quite aware of that. Also, when you're taking that on, be very aware of the resources. Do you have them? What kind of case is it that you're taking on? Again, with a legal clinic, this is probably less of a consideration. It's just, do I have time that evening to be able to go and provide those services? But if you're actually taking a case, if you're engaged in litigation, is this, several years of litigation in the federal courts, and do you have that time and, someone that's not going to be paying you to do that, or paying you on a limited basis? Or maybe it's not that kind of case, but you need to be very aware of that as you're getting into the case, and maybe evaluating it throughout about what you're honestly able to do or not do for the client. And be aware of that, which is related, of course, to what does this client really need? What are the services that I can provide to them? And is that what that client needs? Not every pro bono client and pro bono offering attorney is a good fit. There may be any number of situations where you go, this isn't the right one for me. There's obviously no shame in anyone from that. Go, hey, need to look somewhere else. And these referral programs and everyone else are excellent at making sure they try and match those things, those clients and attorneys up on the best way. So if you need to pass on a certain client, there will always be another client, another case that's ready for you that would be a better fit. So just keep those things in mind, because again, like I said, this is the idea of providing competent services, including, do you have the resources? If this isn't your primary field, how can I become aware of that? Through talking to someone else, having the resource, legal resources, et cetera, or, the time and energy that it needs for this case and what this client particularly needs. Diligence, which is another one. And generally speaking, what I will say, with the few cases that we have come through the office, and I think April can probably back me up on this, if the problems we've had is when an attorney has taken on a pro bono case, and what I'm going to say is, does not treat them as a normal client. And there are two ways that can happen. One is they devote too much energy to this client because they're very quote unquote needy in this sense. They need a lot of information, they need a lot of this. And so that can cause a little lopsidedness in favor of the client. The other is, of course, that pro bono client that's not paying is always at the bottom of the stack. And that can cause, obviously, a whole slew of other problems, including diligence. And we'll talk in a moment about communication, because you really do need to make sure you are treating this pro bono client like you would, they are any other type of client. So when they need work done, you're just getting that work done. You know, if they have the biggest fire that needs to get put out, that needs to go to the top of the list. If they don't, you know, they can stay where you would with any other client. But I think it's just important to have that mind frame that they're just a client, and forget about the fact that whether they're paying the bills or not. Doesn't move them to the front, doesn't keep them at the back. It's just a client. If you're, make sure you have the resources you need to vote for that client. Because again, the cases I can think of off the top of my head have been cases, generally speaking, where the attorney has put them at the bottom of the stack. You know, I'm always going to, yeah, that can wait a little bit longer. That can wait a little bit longer. And then we have months or weeks that go by, and then we have enough, someone that's unhappy with what's happening, and sometimes a legitimate complaint about that, which includes communication. Like I said, you know, I'm not going to return that call right away, or, you know, these diligence communications tend to go hand in hand as we see them in the office, because as soon as you stop doing the work, you don't want to answer the phone call. So that one goes to the bottom of the list, because I have to have an uncomfortable conversation because I didn't get the work done yet. I haven't filed the motion or the response, or I haven't done the you know, written the letter that I said I would write, whatever the case is. So you stop calling, or, you know, and they're calling more, you know, those can be problems. But it's also make sure with those communication issues that you have those limits. We have seen the pro bono clients that have, you know, because they're not paying for every 10th of a minute that they call you, might call a little bit more. And like I said, this is where you need to think of them as any other client, in the sense of, if you need to respond to that phone call, you need to respond to that phone call. If you don't, need to make sure you're being clear about putting those limits with those clients and say, I will get to that. I've told you what this timeline is, or whatever the case may be, and putting those appropriate limits in place to say, you know, just because you call me 4 times a day doesn't mean I have the time to answer you 4 times a day. But make sure you are communicating with those clients. The other thing that I will say with regard to communication that does come up is remembering, again, I'm going to kind of keep hitting on this point, that the pro bono client is like any other client. So you need to consult with the client. We have seen a couple of cases, because sometimes pro bono clients may fall into a less sophisticated area. They may not be as sophisticated as some other clients you're used to dealing with, and lawyers that then think, you know, I just really know what's best anyway. You know, just talking to the client's going to confuse them, so I'm just going to make these decisions for them. You still need to consult with the client. You need to explain them, keep them informed of what's going on, just like you would with any other client. And you need to comply with reasonable requests for information. And I'm going to say reasonable, because if they say, call you every morning and, you know, send me 3 more copies of what you sent me yesterday, you know, that might not be reasonable. But if they said, hey, can you send me a copy of that motion you filed last week? You know, go ahead and provide that information. And to document, which you'll see, which is also the idea of, I have seen a couple of cases. Again, we don't see a lot of cases, so I'm pulling on half a dozen, I don't know. It's not that many. I don't want to over exaggerate, but the ones that do come up, there tends to be less of a diligence with taking notes and documenting the file about what is or didn't happen. And don't do that. Just, again, like you would with any other client. Certainly, again, especially with billing software these days, you know, just bill like you would everything else. Just don't send the bill. But, you know, have all of those same records in there. Just because it's pro bono, you're not charging, doesn't mean you shouldn't have that same record keeping that's going on. And if you're taking a note of a phone call, it should have that same note in the pro bono file. And again, like I said, just make sure you're keeping those expectations realistic for pro bono clients, just like hopefully you are with other clients, and not setting unreasonable expectations either for, you know, how fast you're going to return a phone call or how much work you can get done. Just make sure you're being very honest and direct with those clients. Excuse me. And fee agreements. This obviously applies a little bit beyond the scope of the legal night. Like I said, it's not the determining factor in whether you represent or not. But even if it's, you know, you're taking on a case and you're doing it pro bono, so you're not going to charge them costs, use a fee agreement. It just makes everything clear. Obviously, as you hopefully know, in the rest of your practice, fee agreements are just a great opportunity to set a lot of expectations, as we just talked about, and B, just be clear about what the scope of that representation is. That's now a requirement under Rule 1.5 that you be clear on the scope. Because one, if you're just representing them, on this on a cannabis issue, but they now have an eviction case, but you're not going to handle the eviction case, you want to make sure you're very clear about that. Or now there's a divorce issue, or now there's a criminal issue, or now there's a and you're not handling the rest of that. The fee agreement is a great thing. It's certainly helpful for that reasonable expectation of what the attorney-client relationship is. If you remember, we talked about that not too long ago. This is where that reasonable, reasonable component can really come into play, because we do have clients that call us sometimes. Oh, I'm sure they were representing me in my criminal case because they were representing me, on my eviction case. And, when an attorney can go, here's the fee agreement, I was very clear about what that was, any additional expectation for the client, even if they actually had it, it might not be reasonable. So, and again, this can be very clear when it's a limited scope. That's going to also be absolutely necessary, really, for that informed consent under the rule to say, I wasn't going to enter an appearance, or, I was only going to represent them for this one hearing, or whatever the case may be. You can have that in the fee agreement, and it's just an absolute wonderful opportunity to define that. And of course, in part of making sure that you're being clear about that, when that representation has come to an end, be clear about that as well. Confirm that. We have had those issues. This isn't related to pro bono particularly, but attorneys who aren't very clear about when that representation ends, and the client has an issue that comes up, 6 months later, they still think they've got a lawyer. And when that's a little unclear, like I said, if it's reasonable that the client still thinks you're their lawyer, you may still be their lawyer. So make sure you're very clear about that. And don't think of it as having to be such a particularly negative thing either. You don't have to say, we're done, stop calling me. And hopefully you don't do it that way, but you can do it in a way that says, thank you for the opportunity, et cetera. Even, include some other information that you might have. And file a motion to withdraw. So the court obviously is very clear on what that, if you're in court, there was litigation about when that representation ended. I'm also going to say that, and this is a little bit related to what I was talking about a little bit earlier about the whether you can take on the representation. So the part of this, and this maybe is a little less with this particular subject matter, but I do like to talk about it, is that make sure you are in the right place to take on the representation. Because in those handful of cases, and I'll keep saying it's a handful of cases, that we see where the client, where there's been a problem where the client has, it's when maybe the attorney is not in the right, I'm going to say in the right place. So make sure, because some of these issues in pro bono work in particular, like I was saying, can get quite emotional, or you can get quite emotionally invested. And that can be a problem when you're supposed to remain this, advisor, this cool, collected, independent person from the process that can provide advice to your client, who can provide this representation. And if you get too emotionally involved in it at times, or you just have other issues going on in your life that make that difficult, then you need to be aware of that. So that's just a good practice for everything. It's not particularly, it's not limited to pro bono in any way. But when we're talking about pro bono, some of those cases in some areas of the law can get, can be emotionally triggering or can be otherwise. So make sure you are practicing your own self-care in, I would say in your practice and in your life. And there's a lot of resources to help you with that. We'll put up in a second some of the information about the Colorado Lawyer Assistance Program. That's a great resource. Hopefully everyone here is at least somewhat aware of that. It's very confidential. They can provide you, direct you in the right direction. But again, are there, mentors that can help you? What kind of practice do you have? This is so individual that it's hard sometimes to talk about on a broad scale. But, again, are you a solo practitioner? Are you in a firm? What kind of resources are there to make sure that you have the support for your cases, but in your own life, and not to let these things take over your life so to the point you get burned out. Again, when we've seen some of the cases that I want to say have gone wrong, when there's been something that's gotten to the point of having an issue, it is often because something else has happened. And it can be something personal in your own life that all of a sudden is affecting you too much and you can't handle it, which is why you kind of have to have this constant evaluation, really with your clients about, can I provide the representation? And we kind of gloss through that maybe a little quickly, but 1.7 has that same, issue with your own conflicts of, can I do this? Can I provide the representation that my client needs? Rule 1.1, the competence, am I in a spot where I can provide that kind of competent representation that my client needs? So just be aware of that. That's, don't take on too many cases. Again, we certainly support that. Everyone wants, hey, great, have to do that. That's why we want to recruit as many people as possible to try and do that, because there's such a great need. But make sure you are in the spot that you can provide that good representation, because if you start taking on too many cases and you can't, represent each client to what they need, then you're not helping your clients. So better to help those few that you can well than take on too many and not help anyone particularly well. So, which includes, again, like I said, that representation, do you have enough other paying clients so that you can take on some pro bono clients and have the time and mental energy to be able to do what that client needs, and keep those limitations when you need that. So there are some resources. Obviously, you can get more information from our website. There's also the Colorado Lawyer Assistance Program that I was referring to a minute ago, the mentoring program, the camp. Please be aware of that, especially any of you lawyers that may be more recently in Colorado or more recently licensed. That is often an excellent resource to be able to be matched up. I mean, not related specifically to pro bono, but just in your practice area or as a newer attorney, to get in contact with someone. And we have heard nothing but great reviews from that as to how well that has happened. It is just a fantastic resource. Be aware of a couple of the ethics opinions that are out there as well that can be helpful in this when we're talking about that. There's the Ethics Opinion 101 about unbundled services. So again, these limited representation, if you're just handling a particular hearing or motion or, handling those kinds of issues, or also Ethics Opinion 117 that's more specific to these legal services that we're talking about. So I know there's probably any number of questions, and normally I'll admit with fewer of that, I'll try and address some of those here, but I think rather than do that, I'll probably try and transition to even a little bit earlier to Rachel, so that we can maybe move through her presentation, and I'll hold on there and also try and participate in the chat as well. And if there's some other questions, maybe we can handle generally speaking at the and we can go through that part of it as well. But I'm trying to be conscious of the time as well, to make sure we can have a little bit of time there, so we can, if there's some questions that have come up, especially after Rachel gets more specific into what this program and what these issues look like, that might generate even more questions about the pro bono issues. So with that, I guess at this point, I'll turn it over to Rachel or Tony.
Absolutely. Thanks so much, James. And that was really good information. And April's been doing a great job of answering and responding to chats as well. You can go look at them. But Rachel, it's all yours. Thank you.
James, can you just end screen share for me, please?
Oh, yeah, there we go.
Perfect. Okay. Morning, everyone. Thanks, James. We always love hearing from OARC, so good to know all these rules. So a little bit about me, like Tony had mentioned, my name's Rachael Ardanuy. I have a law firm based out of Denver called RZA Legal. All I do is work with cannabis and marijuana and hemp companies and their partners. So landlords, investors, vendors, ancillary companies, all of that. I have served as an expert, a regulatory expert in arbitrations in cannabis law. Like Tony had mentioned, I'm the immediate past chair of the Cannabis Bar Association's Cannabis Law section. If you've never come to a section meeting, please join us. They're on Zoom for now. The first Thursday of every month at lunchtime, and we discuss current events, what's going on with our section. It's a great way if you are interested in adding cannabis law to your practice, to just really get some networking in and ask questions. Everyone's really friendly and helpful in the section. Like she mentioned, I'm licensed in Florida and New Jersey as well. A member of their Cannabis Law Special Committee for the New Jersey State Bar. Believe it or not, ABA, the TIPS section has a Cannabis Law and Policy Committee, which I'm a vice chair of. So if there's any ABA members here, be sure to check that out as well. And these are all links, so you can check out these great organizations. So these are the quick things I plan on discussing today, a few more of the ethical issues, and then pretty much a primer on what the Colorado commercial cannabis industry looks like. What is social equity? What is it? Who qualifies? Who are we helping? And then what common issues you'll be facing as a volunteer attorney working with social equity applicants, and then some potential pitfalls and other resources to help you out. I do want to just circle back on two things that James talked about and just make very clear sort of, he mentioned too, like know the rules of the program that we're talking about. So the program that we're talking about is the Social Equity Pro Bono Assistance Program, and the offering of the program as it currently stands is a 30-minute consultation. That is it. So that is what we're requesting volunteer attorneys sign up for, is just a 30-minute consultation. It's not for any ongoing cases. And we leave that, we provide that freedom to each individual volunteer attorney and that potential client, whether they want to go on with representing them, whether it's in a transactional capacity, if there are any other sort of hearings that may happen, for instance, a public hearing for a licensing matter or something like that, or a regulatory compliance issue, something like that. But the scope of the program right now is 30-minute consultation. And I can't tell you how often I hear feedback from the various stakeholders when it comes to the cannabis industry, like the Marijuana Enforcement Division, the Office of Economic Development and International Trade. There is a cannabis business office that was established by law 2 years ago to assist social equity applicants. Denver, the constant feedback that all of these stakeholders and licensing authorities give us is they need legal guidance. That is the biggest hurdle and barrier to entry. And even though some of it, there's lots of educational materials out there, it's just hard to navigate because of the way our system works here in Colorado for licensing. And so that's really the biggest concern that they're looking for, is just legal guidance. And so with that said, I hope you consider volunteering with the program. So like he mentioned, which rules apply? They all apply. In many respects, advising cannabis industry applicants and members is no different than any other sort of business venture. We're not the first regulated industry in the world. So certainly there's skills that you all have that will convert to assisting cannabis companies. So I have a few of these rules listed, which sort of echo, what we've already talked about, James, but, competence, that's what we're working on a little bit today, is getting you sort of a baseline competence of what these social equity applicants are going through. So you can identify within your skill set, is this something I can help with, or what can I help with, and limit that scope. 1.2, which we talked about, avoiding and assisting clients in criminal or fraudulent conduct, and particularly the comment to that rule that gives us the green light to assist, cannabis clients in Colorado, while, providing to them what the current federal policy is, obviously still illegal. As an attorney in Florida and New Jersey, and my team being licensed in other states as well, New York and Massachusetts, not all states protect their lawyers, and not all states have valued the fact that this new industry needs legal guidance, and lawyers should have a clear understanding of what they can and cannot ethically do in representing folks in this new industry. And so, I'm very grateful that Colorado has had the foresight to make clear to lawyers that you're not going to imperil your license from an ethical standpoint by assisting these clients in navigating this new industry. Communication, rule 1.4, and then fees, any sort of concerns with creative fee arrangements, things of that nature. There was some mention about the fee, James talked about the fee agreement. In this program, we have prepared a limited scope of representation document that will need to be signed by the client before they get their consultation. And furthermore, there is an intake process. So I know that some of the comments in the previous, during the previous discussion was, how are we going to perform conflicts checks, et cetera, et cetera. And I think, between the rules guiding that issue that April had shared in the chat, as well as the fact that we will have, you're not going in totally blind, everyone, in order to even participate, an intake form has to be completed, and the lawyer will receive that information ahead of time. So they'll generally know what the questions are that this applicant is seeking assistance with. So we have some processes put into place for that. Few other rules here. Again, like you mentioned, they all apply, but these are the ones that we find sort of come up over and over in business, and not just business, but cannabis business. A lot of times, a group of individuals will come in for a consultation, and they have this unified vision, and then by the time you've gotten through explaining what the regulations require and what the different background checking requirements are and things of that nature, you wind up there leaving your office, and two of them are going to be the landlord, and two of them are going to be the grower, and two of them are going to be the lenders, and turns out they actually are not one party, but they're all have conflicting issues. And so that's kind of the thing that you really want to navigate appropriately. And then of course, organization of the client, 1.13, safekeeping of property, things like that. And then the criminal conduct rules. So definitely be sure to brush up on all of those. And I think, we just had a really great presentation on many of those. So really briefly, very, very briefly, these are the three main, can everybody on mute, please? I don't know if there's a way to do that as a host. Thanks. So in 2000, Amendment 20 legalized medical marijuana in Colorado. In 2012, Amendment 64 was voted on and legalized adult use cannabis and commerce in Colorado. There are a lot of intersecting laws that involve the cannabis industry. It's a multidisciplinary area of law, just like sports law, something like that. It's not just one thing, but many areas of law coming together. So I have here referenced the marijuana code, which is Colorado Revised Statutes 4410-101 and beyond. And then we have a rule code, which is currently over 400 pages. There's extensive amount of rules and regulations that all cannabis business licensees must abide by and be aware of. A lot of times these laws and regulations overlap. Sometimes the regulations go farther than what the law says, because a lot of times the laws authorize the MED, which is the Marijuana Enforcement Division. That's our state licensing authority. They're under the Department of Revenue to do rulemaking. So that said, in a lot of circumstances have a big gap between policy and what these laws say and what they intend, and then the reality of operating a business. And so a lot of times that gap really leads to really necessary interpretation of laws and regulations to figure that out. And that's what you do. That's what lawyers are trained to do. So while you may not need to know specifically what these laws are right now, if you're faced with an issue and, that research brings you to these laws and regulations that apply, trying to use your training in legal interpretation to get them to the right answer. And I will say that, this industry is pretty new, even though Colorado has been doing it longest. And the regulators are pretty open and understand usually that we're all building this plane as we're flying it. And so it's important to have an open dialogue and understand that you can have an open dialogue with the regulators. Obviously, they're not going to answer legal questions. But I have found that they've been very easy to talk to if you do have sort of questions and you want to proactively get ahead and say, this is how we're, interpreting this. Are there, instances where you've interpreted it differently, or, any issues spotting, and that the regulators do tend to be very helpful with that. So social equity in the cannabis industry, what is it? Why is it important? We're seeing social equity initiatives pop up in cannabis programs state by state. So I guess I should back up just a little bit because I don't know who all is on the call, but many of you may or may not know, but cannabis is still federally illegal. It is still listed as a Schedule I drug under the Controlled Substances Act. And so states have been legalizing it under their state laws. And, so we have this discrepancy. And so it's a patchwork. It's not common laws between each different state. But since, Colorado legalized, like I said, for medical back in 2000, for adult use in 2012. And those were both ballot initiatives, and none of them really discussed equity in cannabis or the results of the war on drugs or anything at that time. States that are legalizing now, we are seeing that baked into their programs. Like I said, I'm licensed in New Jersey, and they have a pretty robust social equity program in their licensing scheme. And so we're seeing these initiatives sort of baked into programs that are coming about more and more now, but we're kind of catching up from behind because our system was put into place with no social equity initiatives. And so the aim, like it says here, is to provide equal opportunities for all people while taking into account systemic inequities or inequalities and the disproportionate impact on certain groups. So, as we know, so the systematic inequalities in every single U.S. state, we know that Black people are arrested at higher rates than white people for cannabis possession, despite equivalent use between the two demographics. This has trickled down even in our own program. For instance, initially, the cannabis program in Colorado severely restricted individuals with any past cannabis convictions from participating. And so because we know of this systematic inequality of arrest for cannabis possession, that trickled down to essentially leaving out or forcing out folks who had those convictions, which resulted in inequalities in the industry. And now we're trying to catch back up. The governor does have what they call wildly important goals, WIGs, about diversifying and providing more inclusivity in the cannabis industry. And part of that is this social equity initiative that we've got going on in Colorado. Like Tony Ann mentioned, this is a new issue, a new program, but the Marijuana Enforcement Division created a social equity advisory work group to get stakeholder involvement and feedback to see how can we get this more successful and see more results that they want to see as far as the diversity in the industry. Not just diversity, but social equity also was, like I said, specifically for folks who were impacted by the war on drugs, negatively impacted needlessly. And so it's really trying to assist those who have that background as well. So the legislative history in Colorado for social equity, like I said, we're catching back up. If you recall from a few slides ago, 2012 is when the voters approved adult use cannabis and commerce. It took a few years to get that commerce actually going. 2014 is when dispensaries first started opening in Denver area. And so, years later in 2019, the legislature created an accelerator program to provide technical and capital support to the accelerator licensee. One of the goals of our advisory group that we're working on right now is to try to incentivize and figure out how to get that program more used, because it really has not been. That said, if you look at the timing, in 2019, that was something that we could focus on. In 2020, a lot happened, right? Worldwide pandemic. And then, so that really caused, I think, the focus to shift to other areas of public, health, safety, welfare at the state level. But that being said, in the year 2020, there was a law that was signed that expanded the accelerator program, and it also created a social equity licensing regime. And so it created qualifications and a definition for which individual owners would qualify as a social equity applicant. That's what that SEAs means. It created the office of the Cannabis Business Office, which is part of the Office of Economic Development and International Trade, and it earmarked $4 million for grants, loans, and the creation of the office to assist social equity applicants and for technical assistance and other things. And then it provided some rulemaking for the MED to administer and implement the program. So March of 2021, the Senate Bill 21-111 was established and created that's what created the fund through the CBO. And so they just finished one round of issuing grants, $25,000 and $50,000 grants to social equity applicants. They're going to have another round of grants and loans. I think actually just grants in, October, November time. And we should see another one next year. So that may be some assistance we might be seeing from social equity applicants is, we're applying for this grant. Could you help me review this grant the grant proposal that I'm writing? So, just as an example of one of the things that may come across your desk as a volunteer attorney with this program. So, I'll back up again, and now you'll probably hear me say that a lot of times. So Colorado is a dual licensing state. You have to have a business license from the state Marijuana Enforcement Division, and also a license from the local entity that where the business will be located. And so some local governments have adopted social equity into their local licensing schemes. For instance, Denver in 2021 pretty much created exclusivity for all new licenses to be social equity. And then they've also made it so that only delivery and transporters must be social equity. And so if a dispensary within Denver wants to do deliveries, home deliveries to patients or customers, they have to work with a transporter, and that transporter has to be a social equity applicant. There actually is pending legislation in Denver that there will be a hearing coming up here soon with Denver City Council on making that exclusivity indefinite and to make a few other changes. But that'll be in a few weeks in Denver. But for the most part, a lot of local governments have not yet implemented social equity into their local licensing. And so it's kind of business as usual at the local level. that said, it would still be valuable to have that social equity qualification at the state level. So this slide talks about the qualifications at the state level of how you can become a social equity applicant. And that is specific to an individual. And so they must be a Colorado resident. They must not have previously owned a marijuana business where their license has been revoked. And then one of these three qualifiers at the bottom. So either resided for at least 15 years in a disproportionate impact zone area or opportunity zone. If an immediate family member, it's all listed here, has been charged or convicted of marijuana related charge and arrested or convicted or subject to civil asset forfeiture related to that, or household income in the year prior to application, less than 50% of the state median income. So one of those three plus the other two at the top. Now, many of you may be aware, cannabis law is constantly changing as we go. I mean, literally day by day, week by week. We just recently had an opinion come down from the First Circuit Court of Appeals that held that in Maine had a residency requirement for medical marijuana businesses. And the First Circuit just applied the Dormant Commerce Clause to their medical marijuana program and said that is unconstitutional under the Dormant Commerce Clause as it relates to their residency. So while while this is not for any ownership, I guess it kind of is if we're talking Denver, because Denver says you have to be social equity. Keep an eye out to see if there's any challenges to the Colorado residency requirement for social equity as it relates to the Dormant Commerce Clause and there being concerns of it being unconstitutional. But that being said, this is the program right now. So I like to keep this slide in here because I think there's skepticism about legal representation in cannabis on both sides, both when it comes to the attorneys as well as for the clients. And what I've run into with attorneys who are hesitant about working with clients in the cannabis industry, it's usually these two things: ethical concerns or lack of precedent or experience. And so hopefully James's presentation made very clear that, while there are ethical parameters when dealing with any sort of client or business client, that there's no specific ones that are going to, imperil your professional lawyer license specific to working with cannabis, so long as you're following the guidelines of the rules and the comments. And then lack of precedent and experience. Many times throughout my day, I think this is something we've never faced before. So many issues that my clients face are always novel and very interesting, but that doesn't mean we don't have a precedent. Like I said earlier, we're not the first and only regulated industry, and there's many industries that are comparable where we can say, well, this is a very similar situation. This is how it was dealt with in that regard. And then as it relates to experience, every single person working in the cannabis industry now has pivoted in from something else. And so, your experiences and legal training and skills are certainly compatible to working with cannabis businesses. And, again, we have the resources for you. There are many organizations out there to help get you up to speed, to help with that competence and experience aspect of, getting over the being skeptical about working with cannabis businesses or cannabis clients. And then as far as the clients, where their skepticism usually lies is, a risk of documentation. If there's someone who has worked in what we call the legacy market, essentially working in cannabis before it was legal, then there is a concern of documenting and being, creating evidence, criminal evidence against one. And so sometimes that mindset is hard to get over when coming into the legal world of, regulations and needing to have contracts pursuant to the regulations in many cases. So that concern of documentation, I think, stops people, the history of sort of handshake deals and not, again, like creating evidence of what may be considered criminal in certain cases. A mistrust of attorneys is certainly something. One thing that I have encountered is that many folks who, again, previously worked in the legacy market only encountered attorneys when there was a criminal matter that came up or issues related to criminal matters. And so, I think it's just a lot of folks just don't even know that there are attorneys out here that are trained and experienced in working with the legal cannabis industry, and that we're not all just criminal attorneys, trying to keep you out of jail for, criminal related marijuana cases. And then lack of experience too. There are folks, again, that whatever their background is, maybe they were not used to using professionals or receiving professional assistance in the form of an attorney. So I think that there's skepticism on both sides. And so we're hoping that this program will let it be known that, to both the clients and the lawyers, that there is a way to provide assistance, well-needed assistance, and also gain that experience on the attorney side. I think this is an important one to share as well, that we are a lot more alike than you think to cannabis business clients. If you take a look at this list, they're all exactly the same. Okay. So, sometimes it's hard to wrap our minds around our clients' issues when they're dealing with a highly regulated industry, but our industry is highly regulated, as you know. We just talked about the rules of professional conduct, pretty robust regulations that we all have to be aware of. And they're so robust that we even get ethical opinions that talk about how these rules get applied in certain circumstances, right? Marijuana code, very similar, very robust regulations on what they can and can't do. We're all limited to advertising and what we can and can't say. So are cannabis clients. A lot of lawyers are business owners, like myself. I own my law firm. It requires a niche understanding of a specific subject matter. As we all know, people come to lawyers because we understand this legalese that's so challenging and complex and confusing sometimes. To our clients who, may be excellent at doing the things that they do, but we know nothing about, right? And like I said here, like weed, right? Like I don't know, how to grow cannabis, but I know the regulations for commercial cannabis growers, and I can help guide them to follow those regulations. And then, high stress, right? And I skipped over the top ones here, but we have to renew our bar licenses every year. They have to renew their licenses every year. We have to go through background checks and fingerprints and extreme financial commitment to get our licensure, and they do too. So I think, if you think of it from that perspective, we are a lot more like our cannabis business clients than we are different. So moving on to kind of the main issues that we find face social equity applicants. And this is sort of the meat of the, things that we'll be seeing requests on from these applicants. Oops, let me back up there. So, we're trained, we have the skills to guide clients on legal issues. If you're a business attorney, you're used to also guiding them on business issues. But that being said, we're not business advisors. We're, if this is the business you're doing and these are the issues you're facing, here are the legal consequences of those, right? So I've just listed out a number of things. I had a question in the chat earlier about can we limit the scope of assistance? So again, the program itself is just the 30-minute consult. That's what is the current limited scope. But if you find out during that consultation that really they need assistance on reviewing their licensing applications that they have to submit to the state, or a contract to try to, get in with an accelerator, and they can be an accelerator and they can work with an accelerator endorsed licensee. It's those sort of limited issues. Then if the volunteer attorney wants to provide the ongoing support and the applicant requests that support, that's the point at which the lawyer and the client can decide how they want the continued scope to go. If they continue to work in a pro bono capacity, and obviously we have to be in contact with Tony Ann and Katrina and the bar staff about this. But if you do go on to continue work, let's just say someone comes in, they need assistance on reviewing a contract or something like that. And during the consultation, you realize, okay, there's not going to be a conflict here. I have the bandwidth to do it. My mental health, my physical well-being, I'm in good shape to take on a pro bono client, and I can take it on fully pro bono because I feel like these people would not be able to afford this without my assistance. The bar will continue to cover that work that's done pro bono under their malpractice insurance. So that's important to know. If the volunteer attorney decides at that point, yeah, I'm happy to work at, review this contract for you, but based on the information we received here, it seems like this is something that, maybe I want to put my pro bono offerings to someone who truly doesn't have the funds. There may be social equity applicants that have funds. Okay. And we talked about, if they fall under one of those provisions of maybe they just lives in an impact zone, but maybe they're doing fine financially now, that's between the lawyer and the applicant to decide what that cost may be. Maybe they do, if they do ask the pro bono attorney, can you, after this 30 minutes, would you review this contract for me? It'll be between the lawyer and the applicant to decide. And if they decide to do it for a low bono fee, or even at whatever the regular rate may be, that will then have to be governed by a contract, a fee agreement with the attorney separately from the bar association. And then the bar association is not going to cover malpractice for any of that work. So just something to think about when you're making the decision at the end of your consultation. Do I have the bandwidth to take on this case? Do I want to do this case and continue on a pro bono matter? And then, and then being in contact with the program, so that way we can know whether, keep track of that case and when it ends, et cetera, for malpractice purposes. So that was a lot right there, but just wanted to sort of share how practically it's going to look when you're volunteering with the program. So these tend to be a lot of the, legal and regulatory issues we come into: standard operating procedures, if there's a recall, if there's an investigation going on, all these different things. And then the business issues, is something advantageous? The one thing I run into with working with social equity applicants, and many of them being folks who have not opened a business before, is that they don't have a lot of skills and experience knowing about like a lease negotiation, right? And so while lease negotiations could be handled by an attorney who just does real estate work or, knows nothing about cannabis, you're going to want to work with a cannabis, somebody involved in cannabis to know there's certain things that do need to go in leases and can't be in leases, right? Like federal illegality things, right? We want to carve those out. But many of them just don't know like what's customary in a lease, in a commercial lease. And while, again, that sometimes, can depend on the market, it depends, it's not just legal, it's sort of that legal and business. It's definitely assistance that they need, that, these are sort of customary contract terms. These are contract terms that may help you. Here's a thing that might hurt you. There's a link here at the bottom. My associate attorney, Lauren Devine, she wrote a law review comment that won some awards and was recently published in just a few months ago, spring 2022. So if you have any interest, more interest about social equity programs in the cannabis industry and sort of the comparing and contrasting of different programs throughout the country, including Colorado, check out that link. It's a really good law review article and timely. So now I'm just sort of going to go through the main buckets of issues that I run into when dealing with social equity applicants. And I will back up and just say, before the bar approved this program, I've just been offering them throughout my own firm to try to, get the information out there to social equity applicants, because it can be a long runway until you can get licensed and things like that. And they need that assistance sometimes well ahead. So a lot of times it's just business ownership structure questions, choice of entity, and not knowing, the factors that go into that choice of entity, how you're going to be taxed on things. Cannabis has a major tax issue. There's a provision in the Internal Revenue Code called 280E that prevents businesses that are trafficking in a controlled substance from taking any business deductions whatsoever. And so that really does impact choice of entity. And so if you feel comfortable with typical choice of entity questions dealing with small businesses, but aren't sure on that, you're going to want to make sure you team up with somebody or get a little bit of background on those issues that are specific to cannabis for the purposes of, taking on this client. Fundraising, what is their intent? What's their vision look like? What the succession planning looks like. Are they planning on being a public benefit corporation and what that benefit may look like? And basically all the things that come with choice of entity. So I don't want to harp on many of those things, but since a lot of you handle that stuff outside of cannabis. In many businesses, you really don't need a lot of charter documents necessarily to get going, depending on what they're trying to do. I know the banks, usually want to see an operating agreement, but for licensing purposes, the state and local licensing authorities throughout the state require submission of charter documents. So just registering, your LLC with the Secretary of State alone is not going to be sufficient for these applicants. So even if they know what type of entity they want to start, or if they're just like, I'm a single member, I don't plan on doing XYZ, I just want a single member operating agreement, or I'm just a single member business, why do I need an operating agreement? The reason why is for licensing. They do require that documentation. Okay. So I'm just going to give a quick rundown on the licensing process. And the example I'm giving here is Denver. But like I said, local governments across the state vary on what their process is for business licensing. Generally, the process starts at the state, which is the Marijuana Enforcement Division, which is a faction of the Department of Revenue. The very first step is to be an owner of a marijuana business or a proposed owner is the finding of suitability application. And that's the point at which it's determined that someone is a social equity applicant. So, we're trying to sort of navigate providing services to folks that we really only want to provide to social equity applicants because they're the ones who need it. But at the same time, it's like a chicken or the egg thing, right? They're not officially a social equity applicant or licensee until they've submitted this finding of suitability, but sometimes they don't even know, how to evaluate whether or not they are going to be found suitable based on their background. Like, oh, well, you'll see all kinds of things. Well, my nephew was my son was charged with a DUI and possession, but then the DA did this and he pled to that. And so we may run into situations where people fill out the intake form and say, I think I'm suitable, and these are the reasons why I think I am. And so there may be situations where we're running into someone where we're doing a consult to determine whether they are found suitable. They will be found suitable as an equity applicant, prior to that submission. One of the things we're working on the advisory group is how to make the barrier to entry a little lower. To submit a finding of suitability to the Marijuana Enforcement Division is an $800 fee, and they have to, that has to be paid at the time of submission, whether or not they know they're going to qualify. So that right there is an initial barrier to entry. So, so we do have on the intake form, have you already been found suitable? And if not, what criteria do you think would find you suitable? So that may be something that comes across your desk in a volunteer situation here. Once the suitability comes back, that they're approved to be an owner, they have 1 year from that date to apply for a business license. They're not considered an owner then, they're just found suitable that they could be an owner. And that's not specific to social equity. Every owner, 10% or more of a marijuana business in Colorado currently has to be found suitable before they can apply for a license. So that's right there is a runway, because the state has up to 120 days to approve those. They tend to approve them in 3 to 8 weeks lately, but if someone's got a lot of background to go through, it could take longer. So when someone's ready to submit the business license application, they come to you for that. We want to make sure they're already been found suitable. The next step was submitting that business license application to the state with all of those supporting documents. Like I mentioned in the last slide, charter documents is one of those documents that you have to have. A floor plan drawn to scale, doesn't have to be stamped by an architect or anything, but for the state, they want to see a floor plan drawn to scale, security schematics of where the cameras are, charter documents, financial source documents. So like if they're getting loans or any other sort of financial sources that are not of ownership, we have to provide all of that information. And like I said, fingerprints, bank records, that kind of thing. And so sometimes they need assistance with that. A lot of times people come to me in our consults and we explain this process and they're like, well, it's a form, I can fill out a form. It's a challenging form. It is a challenging form. And so definitely, we have the skills as attorneys to assist with those kinds of things and the supporting documents. Now, once the state approves that business license application, they have between 45 and 90 days to approve or deny an application, new license application. Presuming that they're approving it, you're going to get a conditional approval. And then that's basically a license that says, well, you're halfway there. You can't operate until you have that license from the local government on your wall as well. And you need to finish the process of getting your local license within 1 year of getting the conditional approval. So we talked about a year from suitability, and then to submit the business license application. And then once that's approved, a year in order to get your local license approved. So these things can happen kind of at the same time, some of them, right? It could be a risk if we're not sure on the business license side as far as moving forward with the city. But once you submit the business license application, as it relates to Denver, the Marijuana Enforcement Division will send them a copy of it. Then Denver will say, okay, come apply with us now. So they have a online portal to submit a local license application with Denver. And they also require a lot of supporting documents, most of which also get submitted with the MED, but there are some additional documents that Denver requires. Denver has a public hearing requirement for stores and hospitality and sales licenses. So they don't have a public hearing requirement for new grow facilities or new infused products manufacturers, but for these store types, they do. And that's a needs and desires standard. It's very similar to the liquor standard. So if anyone here has done liquor licensing and they are willing to offer pro bono representation to a social equity applicant in their licensing hearing, pretty much the same standard, very similar hearing packet, very similar standards, same assistant city attorneys and hearing officers you'll be working with. Have here, I listed out the burden of proof here. So if anyone here is familiar with licensing, it's practically identical as far as the burden of proof. And then at that point, and this is the point that it's hard to explain to brand new owners who are trying to get into this industry, that don't have millions of dollars backing them, is only once you meet the burden of proof from Denver, and then the hearing officer recommends approval, and then the director of excise and license says you are approved, that does not mean you can start growing cannabis at that point. Then that's when the inspections happen. And this is where we run into another point at which we run into folks really needing assistance. So the inspection process, you go through the local licensing, you submit the application, you go through the public hearing officer recommends approval, director says you're approved. Now you need to go through all these inspections. And once you finish the inspections, we will issue you the license. So the inspections process is very similar to many other businesses in this in the city of Denver. And so, making sure your zoning is right. If it's a redevelopment, if you don't have a certificate of occupancy, it gets them really into that development realm, which still sometimes they just need 30 minutes to be explained that process, despite the fact that Denver has this process laid out on their website and there's lots of resources. I tend to be answering a lot of education type questions on this process. And I think you will expect that as well. And so These are both links at the bottom here, Marijuana Enforcement Division's website, Denver Marijuana Licensing website. If you, like I said, there's a ton of resources there to get you up to speed on what the process looks like beyond my, very shortened explanation here. Now, again, I talked about Denver, but it really varies wildly depending on what local government you're looking at. Please remember that many of the areas, the local governments in Colorado still do not allow cannabis commerce. And so, if somebody's coming in and saying, I have this great idea to open a dispensary in Jeffco, that's going to be something you're going to want to say, have you done the research on whether Jeffco allows licensing at the local level? Let's look that up. The answer is no. So that's going to be, dead in the water, that plan. Let's just pivot to a local government or look at what local governments are accepting applications. So all of those are things to think about in the licensing process. And, some local governments have no hearing process at all. As long as you check the boxes on their application, they're going to issue your license. And, here in Colorado, we have urban areas like Denver. We represent clients in Southern Colorado, in the Western Slope, and they all do it very differently. So, even just assisting a client or a social equity applicant at one of these consultations on knowing what is the process that I can expect so I can know the right order of operations. So I'm not running into I haven't done things out of order and, losing thousands of dollars, right? A lot of folks may want to sign a lease right away and not realize that licensing could take a year, and then they're paying a year's worth of rent. And if they known that, because of the long lead time, we could have educated the landlord and negotiated a little harder on, abating rent until licensure and other sort of ways to limit the initial outlay of funds before they can even start operating, that's going to help substantially help these clients. So real estate matters is these are a big issue when it comes to cannabis businesses. Local governments who do allow cannabis commerce, a lot of times they have suitability requirements on the property that they have to be a certain amount of distance away from other types of businesses, daycares, schools, halfway houses, things like that. Each local government has decided their own. That's something that's in the proximity of local governments to limit and manage time, manner, and place of these types of businesses. So they really vary wildly. City of Boulder, I want to say it's like a 500-foot distance requirement from like schools and daycares. Denver is 1,000 feet. I was just talking to the county attorney the town attorney for the town of Wellington. They recently approved cannabis commerce. It went to a vote, and it was one vote that made the difference to legalize cannabis commerce in the town of Wellington. Well, unfortunately, their ordinances were drafted such that the only suitable properties have to be 2,000 feet away from these other types of businesses. And guess what? 0 properties qualify in the town, and the local government can't change, the board can't change the rules on that until January. So important to know that even if local governments say, yeah, we're open for business, like Aurora, we're open for business. We have cannabis businesses here. If they have caps on the number of licenses they issue or limitations on the locations, that's going to change, yeah, you may by law allow these businesses, but there's no room for them left, or there are no licenses for them to apply to. So those are sort of things that we face as well in that state local difference thing that we have to analyze. So other real estate matters that I've been assisting social equity applicants with: letters of intent for a lease, commercial lease negotiation and drafting, due diligence on property, purchase agreements if they're buying land or buying a property, and whether we can make those conditional on licensing, things of that matter. I've also seen people in the past try to buy and sell marijuana businesses via like a real estate purchase and sales agreement. That's really not a good idea. Sometimes that'll happen in non-cannabis businesses where someone may sell their business and it has the property too, and they just include in the additional, additional provisions that, the business is coming along with it. Can't really do that in cannabis. So something to think about. Zoning, if it's a local government that has specific zoning for types of businesses, we want to help do that research to make sure they're not looking in the wrong areas, or at least say, okay, if you're looking in Denver, this is what the regulations say for guiding you on which zones you can look in, right? So help narrow their search for real estate. Some local governments, if they're, out in a real rural area, a lot of times they'll say, well, there's no specific zoning, we've got distance requirements, but everything is by conditional use or special use permits. And then you're going down that road, right? Going in front of planning boards and board of commissioners on seeking conditional use permits related to the activity. And then building the team of necessary real estate professionals. You're not going to have all the answers to their questions. I certainly don't when they come to me, but I at least can issue spot, this is the kind of professional that you need to help you with this. If you need a code compliance, a code analysis done for redevelopment, for, bringing up to code an old building in Denver, you're going to need an architect, you're going to need electrical and mechanical and plumbing engineers to submit those forms, those plans to get your certificate of occupancy. Surveyors, designers. So there's a number of different things that go into the real estate side of getting this business off the ground. Contracts. So here's kind of a list of the main buckets of contracts we tend to see. So anyone who's on the call today who's used to doing transactional work, we need you. Social equity applicants need you. Again, a lot of them, we know what we know, and this is kind of outside the realm sometimes. And so a lot of times we need guidance on that. And then not just the general, like an employment agreement or an IP licensing agreement, but also how does that involve the cannabis regulations? So like, for instance, IP licensing agreements, the marijuana code discusses what's considered a commercially reasonable royalty, and if and how these contracts need to be laid out to be considered commercially reasonable. So there are a few regulatory layers that get poured over some of these types of contracts that we're going to want to pay attention to. And again, if you are a volunteer attorney who's not used to working with cannabis businesses, but you're interested in getting involved, please reach out to the cannabis law section. There's certainly members who are willing to put their heads together with you or provide guidance. That includes myself and my team. But we really want to see a lot of volunteer activity with social equity applicants. We are seeing these programs in other states. I have reached out in California. There's a few. The San Francisco bar has a social equity fund where they assist, with cannabis businesses. So we want to assist. So if you're feeling comfortable with employment agreements, but you're not sure what the cannabis slant on that may be, we're here for you to ask those questions. If it means you're going to assist the social equity applicant, we're happy to help with that and put our heads together. And then the asset and stock purchase agreements. I spent a lot of time previously talking about the startup phase, and that presumes that people are going to be starting a business and applying for a license from scratch. There are two ways to get involved in the cannabis industry, commercial cannabis industry. You can start licensing from scratch or buying an existing business, whether that's just the assets, the licenses, or actually buying the business. And so changes of ownership like that, when it comes to an asset purchase or a stock purchase, depending on the level of how much ownership is changing, if it's over 10%, and the type of transaction we're doing, requires state approval and local approval. And so, if someone says, we came across a situation where we have a seller who, and we're social equity applicants and we want to buy, we need assistance with an asset purchase agreement, again, very similar to other business asset purchase agreements, but certainly some added regulatory, which we're happy to provide guidance on. In fact, I provided a large presentation on that a few years back. I think it was 2 years ago at the Cannabis Law Symposium, which is available on Home Study now on, issues involving buying and selling cannabis businesses and assets. So there are some unique clauses we tend to see in the cannabis contracts, contingencies on licensing, especially when it comes to a social equity applicant who doesn't have a lot of that runway funding to get to operations. Due diligence in asset purchase agreements. A lot of cannabis facilities that may have been operational for the past few years that are now for sale may sound like a great idea to a social equity applicant. Oh, wait, turnkey, this is great, but many of those may contain, mold or other environmental aspects that, while it looks like it's a good deal because it's already built out, that may require intensive remediation, or, maybe you do the due diligence on the licenses. So information about cannabis business licenses are subject to KORA, just like many other business licenses. And so, one of the first things we do if a client's looking into buying licenses is running a KORA request to find out what the history of those licenses are, because negative history follows a license. Carving out references to compliance with federal law. Most landlords you run across who are not used to working with cannabis are going to have standard leases that reference compliance with federal law throughout. And while we have no problem complying with every other federal law, we don't want to manufacture a breach by saying we're going to comply with all federal laws. And oh, by the way, we're cultivating cannabis in this building. So, just making sure that there's, you're not running your client into an issue there. And again, that's going to create an opportunity for education when it comes to landlord or landlord's counsel, or any other counterparty who's not familiar with working in cannabis. Or with a cannabis company. Good faith negotiations in light of regulatory changes. A lot of times we like to add a provision in there that says, if for some reason, I know we came to all the agreement on all the issues, it took a while of negotiation, and now that, the regulators are going to say they have an issue with X, Y, and Z. So, an experienced cannabis attorney is usually going to be able to avoid any sort of regulatory concerns about a contract beforehand, but these changes happen all the time. Regulation changes. We're right in the middle of permanent rulemaking right now, as we do annually in cannabis. So, having a provision that says, listen, this thing isn't just going to die. This deal is not going to die right away. If the MED is asking us to make a change, we're going to work in good faith to renegotiate it to make, to comply with regulatory requirements. Different forms of security rise to the level of different things in cannabis how I'll put it now. We have different terms for different types of owners. There's passive beneficial owners, there's controlling beneficial owners, there's indirect financial interest holders. These are all terms that are defined in the marijuana rules, but there's different regulations that impact the type of security that's provided in a regulated marijuana business. Like, you can't use the marijuana inventory as security unless the buyer complies with all, regulations and gets licensed to be able to take that security. Cannabis businesses still have no access to bankruptcy because bankruptcy is governed by federal law, and federal and cannabis businesses are federally illegal. So there are no remedies currently in light of that. So, how do we structure these terms to protect both the lender and the borrower? And then different seller carry terms, just like in many other business transactions, buying and selling of a business. A lot of times there's a seller carry note to pay off a portion of the purchase. And so, how do we protect both parties and get everybody paid, even once the transactions occurred? One thing we include in charter documents is what we've termed automatic divestiture. And so looking at the regulations and what activities might cause an owner to no longer be suitable to own a business, you don't want to imperil the business license, right? That's like the thing we've worked so hard for. So how do we encapsulate that license against and protect it, indemnify it against any issues that an owner may be facing, right? Criminal matter or taxes or whatever. And then valuation of licenses and inventory, putting in different procedures of how those things are going to be valued and how the parties are going to treat them. So some negotiation and drafting tips I have for you. I talked about the auto divestiture, putting limits on transfers, requiring everything to be subject to regulations, that, you know, subject to regulatory requirements, all legal and regulatory requirements is going to do a lot, go a far way as far as savings. Leases and real estate purchase agreements, like I just talked about, some incentives that, you know, these are not legal, you know, aspects of a lease. They are business aspects of a lease, and, you know, what's commercially reasonable and that type of stuff. So I think there's a lot of room there to guide landlords and the potential tenants on, you know, can we terminate if the local government comes back and says your property is not suitable? You're too close to a school. You know, unfortunately, we have a lot of chicken or the egg situations when it comes to licensing. And one issue that I run into with, especially with social equity applicants who are trying to gain investors, is that, you know, an investor doesn't want to invest until they see they have the license. You can't have the license without already having the lease signed, because it's part of the application to submit. So it gets you in this catch-22 of like, I can't get the money without the license. I can't get the license without the lease. I can't get the lease without the money, and circles back. And so if there is ways that we can cut down the red tape in that circle, you know, that's kind of where I'm talking about with regard to this, you know, rent abatement, or allowing them to get out of a, you know, a lease if for some reason they can't move forward from a licensing perspective. You know, if the property is just a shell, is the landlord willing to provide a tenant improvement allowance? Or, you know, how are we going to handle furniture, fixtures, and equipment if it's grow equipment? What landlord access can they have? You know, a typical commercial lease may just say, like, you know, upon notice or during business hours, and an emergencies at any time. Well, that butts up against the regulation that says visitors have to be essentially chaperoned by an employee or an owner at that facility. Nobody could just come in. You have to sign a visitor log, you have to wear a visitor badge. And so, you know, making sure that, you know, we're building that into the contract. So that way, again, it's the education toward the landlord to say, this is what the regulation says, so this is why we're changing this provision in the lease. Different options to expand if they're in like a multi-tenanted industrial building, or limitations, exclusivity limitations. You're not going to lease to another dispensary in this plaza, whatever, those kinds of things. And then bifurcating closings if you're buying the property. You know, a lot of folks don't want to buy the property if they know their license is not going to be approved. They're not in the business. They didn't want to get into being a landlord. They wanted to get into owning a building that they cultivate or sell in. And so again, sort of like lining up those contracts, so that way if something happens over here, you don't get licensed or what have you, you're not stuck with a building, you're not stuck being a landlord. And then just a negotiation tip here on the asset purchase agreements, that specific due diligence, like I talked about, like, you know, if it's a grow facility, it's been operating for a while, you're likely going to want to have your, you know, encourage your client to go get an environmental scientist, come and do an analysis on if there is mold in the walls or other environmental issues that are going to require remediation, right? Because if they come in and find that there will be, that's going to impact the negotiation of buying those licenses and those assets, right? They're significantly worth less than what everyone thinks because of the necessary remediation that would have to go into the facility. You know, again, making everything subject to regulatory approvals, that kind of thing, what escrow options there are. Not a lot of escrow companies will provide escrow, but there are certainly a few who are willing to. Some more negotiating and drafting tips. The ISP licensing agreements, you know, quality control. A lot of folks I'm running into on the social equity side of things have brilliant brands and ideas for products and brands, but they don't have the money to open a manufacturing lab to create this. And so we're seeing relationships pop up through IP licensing agreements where a brand owner, they own the recipe, they own the specs, they own the design for the packaging and labeling, and they work together with an existing licensed manufacturer to for the licensed manufacturer to essentially white label and create these products for them. And then we have to really lay out in that agreement who's responsible for making the sales, who, like, actually getting sales, not the transaction itself, because obviously that all has to happen through the licensed entity. But, you know, what's the royalty split going to look like? What's the quality control going to look like? How long is this thing going to go on for? So that's one way that we're seeing equity applicants getting into the industry without actually getting in, because they're considered an ancillary brand owner, but they don't actually, manufacture marijuana products. But because they don't have millions of dollars to get a lab started, that's, the easiest way to market or quickest way to market. Employment agreements, this sort of goes to that automatic divestiture issue I brought up, but like if an employee is involved in some sort of action that creates a regulatory issue for the owner, again, the hardest work is getting those licenses. And so if you don't have the licenses, you're dead in the water, you cannot work at all. And so if they're, how do we insulate and protect those licenses? And, that all goes to mitigation down the road. If the licensing authority then says, well, listen, you violated X, Y, Z, and you can point to your employment policies that say, listen, that is not allowed. This is specifically what's not allowed. These are the mitigating factors. We fired that person. We did lots of training with all the rest, we've updated our SOPs, et cetera, like have mercy on our license kind of thing, if it gets to that point, but all toward, protecting that business license. And vendor agreements, making sure that there's specific reps and warranties, that everyone's working in compliance with all the laws, rules, and regulations that are governing the business and the activity, badging, security, licensing, all of that. So a few potential pitfalls to avoid: using a contract template from a non-business matter, thinking it'll be sufficient as is. I should have added as is here, because lawyers are masters at working with, templates and creating case specific documents from a, beginning spot, right? So, maybe using a contract template from a non-cannabis matter, but it's specific to IP licensing or whatever, may be a helpful start. And then, putting your heads together with an experienced cannabis attorney to make sure we're addressing everything in the regulation and all the possible pitfalls that can be avoided. But just starting from your base contract template, I've seen it cause major issues. And especially when it comes to folks who are getting started in the industry and they're drafting their own operating agreements off of like a form website or something like that, or some, legal services provider, but not really having an eye to what their business is. And then, if we have issues down the road involving owners and, we're stuck with whatever provisions were in their boilerplate template, we all know that can lead to significant expense, legal issues on the back end. So trying to get it right from the get-go. Unfamiliarity with current regulation, state and local, major pitfall. I know I said that the rules are very, very long. That doesn't mean don't read them. But you certainly have resources to ask those questions. We have a listserv through the Bar Association Cannabis Law section that you can ask any sort of question, and we can all put our heads together on a regulation. But the laws on marijuana, like I said, in section 4410, 101 and beyond, it's a pretty short article. So I definitely recommend reading through all of that, because it's really not long at all. And then relying on inaccurate knowledge. There's a lot of consultants in the cannabis industry that have zero credentials, but convince people to hire them. So, we know about that in the legal world as well. So just something to consider. The lawyer on the other side of the deal, definitely don't want to rely entirely on that person. It would help if we knew that they were a cannabis, related attorney and have experience with it, but still wanting to confirm. Realtor, and I say you're here, but this was really geared toward the applicants themselves, but realtors, cousins, friends, brother who worked at a dispensary, internet searches, social media, there's a lot of misinformation out there. And so we're trying our best to get really good information in your hands and in the hands of these applicants, so that way they can avoid these pitfalls and go for, be successful. So a few other resources, I've mentioned it about 50 times throughout this presentation, but Cannabis Law Section members, we dedicate our lives to working in this industry. We're passionate about it. And, if we don't know the answer, we can at least put our heads together and help get you, point you in the right direction. We have monthly meetings, like I said, the first Thursday of every month on Zoom. We've got one, I think that's next week, to ask questions. You can ask questions on the listserv via CBA communities. Denver recently put out a technical assistance program for social equity applicants. It is administered through an organization called the Color of Cannabis. They are having 4 cohorts throughout the year. They are in their first cohort now. It's a 10-week program for each group of participants that go through this educational program, and then there's additional assistance provided. So we may wind up seeing some of those applicants seeking additional information or assistance or guidance or whatever through this program. That is just geared toward Denver. Like I mentioned, the Office of the Colorado Cannabis Business Office through OEdit, they have a technical assistance program that is at your own pace and online only. And so I'm pretty sure that's open to anyone who wants to register on that platform to then take the technical assistance program. That's completely free. It is at your own time, self-paced, and really helpful. So I would definitely recommend, if this was a really basic primer on just the issues that are facing social equity applicants and what things we're going to likely to see coming through the program. But there is a ton of information on that technical assistance program. And then many of the folks who may be on this call, this is brand new news I just found out this week that I haven't even gotten to email them about, but we just published the first edition of a cannabis law treatise in Colorado, and it is now available today through CBA CLE. You can save 30% on the book by using that code right there, Cannabis Co 22. Once they sent this to me, I asked if they could change the promo code to legalize it, but they said I was too late. So use Cannabis CO 2020 and you can get 30% off the Cannabis Law in Colorado book that literally just got published like this week. So that provides a ton of information on the intersection of cannabis and other areas of law. So if you're a family law attorney, if you're an immigration attorney, if you're a business attorney, there's a lot of information in there. It is geared toward lawyers, and it is in the link on the form. There's a link right there, Cannabis Law in Colorado. That'll bring you directly to the website to go ahead and purchase the book. But beyond that, like I said, just to wrap up the referral program details, it's the initial ask is just 30-minute consultation. So the next step, if you are interested in getting on the wheel of volunteer attorneys, is to click on that link, fill out the information, and then you're basically just going to be on our roster of volunteers. So whenever we get folks who are interested in a consult through the website, the Bar Association will reach out to the roster of attorneys and say, this is available, who wants to take it, kind of situation. And so, please consider signing up as a volunteer attorney. We would really appreciate your assistance on that. If you have any questions, I have my email address right there. So you can find me or Tony Ann, anyone at the bar. And I just want to thank you all for attending. And I'll go ahead and I'll look at the chat if there's any questions. Legal fees. So in general, if asked about the legal fees associated with starting a cannabis business, what should you tell a client? Well, I mean, that's going to be up to the lawyer and the potential client. A lot of times I see for these startup companies, they have to have pro formas and sort of projections out there. And a lot of times I see, what they put for a line item for legal. I'm like, where do you get that from? I think that a lot of times it's a guess on what they think it might take. And also, maybe from shopping around on different lawyers to assist them. And sorry, I'm looking here. So Aaron mentioned, pointing out just keeping the lights on at a production facility would cost much more than legal fees. I would say, I would agree with that the startup costs, legal fees are not the lion's share of the startup costs of these businesses. It's licensing, it's assets, it's that long runway of paying rent without, having your licenses yet, or like if you're growing, you have that first cycle of plant growth that you're pouring money in, paying operations, paying your team to grow the plants, but not making any money until that first harvest and that first contract gets signed. So there's a lot to it for sure. And last question here, has there been a push to legalize at the federal level? Why is there a lack of attorneys ignoring the federal law? So, we're definitely not ignoring it, because the law, our comments alone to the ethical rules require us to tell each applicant and each client rather that this is federally illegal and we're not assisting you to violate federal law. There has been a push to legalize at the federal level. We just haven't seen it happen. We can't get the government to agree on that. Shocker, but it has been floated a lot. There's currently some bills pending on legalizing cannabis at the federal level. There's also bills pending on if they can't legalize entirely to allow for safe banking for the cannabis industry to be able to avail themselves to banks and using bank accounts, because just like bankruptcy, federal laws govern banks, and so a lot of banks are unwilling to work with cannabis businesses. So I just think it's going to take a while on the federal side, which is why we're seeing the laboratories of democracy, the states across the nation legalizing state by state rather than there being a unified federal shift. But great question. Thanks, everybody. I'll pass it over to Tony Ann.
Thanks, everyone, and thank you especially Rachel, James, and April for really helping us with this. As we discussed, it was to educate you all on this area of law, but also to incite you to hopefully volunteer with any of our programs at the CBA, and in particular with this program with the CBA. We put a lot of links in the chat, and Katrina will send out all the materials as well as your CLE affidavit, as well as a link to how you can sign up to volunteer with us. So look for that in your email. Thank you all so much for all of your time today.